It is not until you hear other people's life situations that you will realize that whatever you are going through is a semblance or a very small extent of what someone else is going through. I'm going to play you some audio of someone going through a situation with child support. Everything that I'm about to play in this audio arises from another conversation that I had with someone who was dealing with the beginning stages of child support. And a caveat, a sense of urgency was being provided to them that there are certain things that would occur if you allow the seed to germinate and turn into a fruit and ripen. This audio conversation I'm about to play to you is what it would sound like when the fuckeries of child support ripes. And I'm emphasizing that in this video to let others who are dealing with the beginning stages of child support, or if you've never dealt with it, either through some type of decree of divorce, whatever it is going on. And also as a message to men in general, that thing in between women's legs, think twice. Because most women out here these days take care of everything out there. But up there, you have no idea what they're planning for your life. And if anyone's instant gratification overrides the totality of what one's future would be like with that woman without looking at certain attributes, that woman can effectively destroy a man's life. All because of whatever is in between her legs or yours. That's the best way for you to consider things so that none of this even comes up in the first place. Pick right. Choose right. Take the time to do so. But to those who are already in the beginning stages of child support related issues, I'm going to play an audio to let you know if you're not careful, this might be what would come up. And subsequently, certain solutions relating to the things that's highlighted in the conversation that's about to be played will be given to you along the way without necessarily isolating the problem and dumping it on your lap and putting you in a state of fear. Always remember that there's always an essence of at least two sides to the equations of things. Where it's allegedly bad, there's always a potential solution to fix it or to prevent that bad from occurring. So with each portion of this conversation and this audio I'm about to play, I would interject and provide you the solution involved in it, as it was mentioned to this manner. And even more important than any of what I've just mentioned earlier is exposure. The more something like this is exposed, outside of the potential victims, the more of it, those who are not victims or will not be potential victims will become aware of how these things work. The greatest enemy of a tortfeasor is light and exposure. And you, the everyday man, regardless of whether what you're about to listen to is a relatable condition or not, the everyday woman, regardless of whether what you're about to listen to is a relatable condition or not, ought to know about it. Because this is what is going on behind closed doors. With people you see and meet every day that you don't know what they're going through. Or those you see and meet every day that are engaging in these activities to screw people's lives over. Exposure is the greatest weakness of someone who intends to take advantage of another. No different than a relationship. I always give this analogies. No different than a relationship. Someone in a relationship treating the other party bad usually don't want others to know about it because there's power in secrecy. In order for powers to be kept, secrets must exist. In order for power to exist, secrets must be kept. There's power in secrecy. In order for powers to be kept, secrets must exist. In order for power to exist, secrets must be kept. when you slowly begin to shed light into the circumstances people go through when it comes to things of this nature, in this case, child support, the more exposure is involved as to what goes on, the more those would-be potential victims will be able to avoid it beforehand. Because the mirror neurons in the human brains allows us to look at other human experiences and abate that or prevent that from happening. Or if one is already going through it, to have the strength to realize that, one, you're not alone. Yes, emotional support is important. Even if you're a man, emotional is important, even if you're a so-called adult. The only issue is most adults think being desensitized is a sign of strength. It's not. So long as you're not on the end of the extreme of things. You see how tortfeasors use this thing called paper terrorism against everyday people, where they just put floods of document into cases. And the solution to that most people don't know, that they expect you not to know. You see the small tricks, because when you know the small tips and tricks that's done to make life hard for people to find solution, you would know how to abate it. Or when it's coming, you see it clearly. So listen very carefully to the following audios.
So I'm standing there, and some nice lady, 70 years old, walks up and gives me her phone number. And she's like, if you need a witness, call me. So I got a witness. I got it on film. The guy is like, is your phone recording? I go, not only is my phone recording, I go, look at my hat. It says, smile, you're on camera. There's a camera in it. I go, I was given to me.
That right there is very, very wise. Everything that you do, you must always have an objective witness. He said, she said is good only in very limited circumstances. As you all very well know, when it comes to this pen and paper thing, that's referred to as hearsay. And the less that he said, she said can qualify under hearsay exception, which we've went over in these videos. Then it's as good as useless. An objective witness is what removes the opinion when it comes to the parties in dispute, which undisputably presents something as fact. In other words, undisputed fact, which can be used as a dispositive matter in your favor, whether you're doing a summary judgment, which requires no dispute, whether you're doing a motion to dismiss, which also requires the fact that whatever is brought against you just has no claim. Objective witnesses would always benefit you. In his case, he had a video. And according to the First Amendment, you have the right to preserve the integrity of any given interaction through some form of record. Objective witnesses are the best types of records, either through video or audio. Always remember, each of these municipal buildings or establishments you go into, there are CCTV cameras everywhere. Even as you're going down the street, it's there. If you are anywhere where reasonable expectation of privacy is not conspicuously, deliberately barring you from being able to exercise your First Amendment right to preserve the integrity of a record, especially if you're a party to that. So the assumption is not that you're spying against someone or you're trying to do something in a manner that's silent, so to say. If you're a party to it, you always have the right to preserve the integrity of that record, to keep that record to be used as objective witness. Because one, memories may not serve you right. They flutter. A bit more might be added based on how you feel about the circumstance. Or you might have omitted certain things and not noticed certain crucial things that would assist you in certain claim, or annulling one brought against you because the objective witness simply preserves the integrity of the interaction as it was. Always, if you find that it's a circumstance where video cannot be done, or you think audio is the most reasonable means because you don't want to give certain things away or alters people's reaction, then engage in audio record. Your video record, if you feel and realize that reasonably, that video record with people in check to do what they're supposed to do, which was what fit his circumstance. As a reminder, remedy begins in your hand, because remedy is the means employed to enforce a right. The means, such as exercising the First Amendment right to preserve what's going on objectively, so that you could go back to it and employ it to get what you need, or to see where the loopholes are, whether you want to study it so that you can see what you could have done better or where you went wrong, or to point out certain facts without any bias. Remedy is the means employed, meaning you have to activate it, you have to use it. It's dormant without your activity to enforce a right or redress an injury. Remedy does not begin or is not brought to life when you start to put that relief sought section in, whether it's your initial suit or motion or whatever it is. That remedy is something that begins during the moment that you know and you see that it's reasonably related to the totality of what you are dealing with. Even if you don't think you might need it, just preserve it so long as it's involving those attached to whatever is going on with you. Again, remedy is not something that occurs when you get to the point where you're suing someone or someone is suing you, because it's just a means that you employ. And even if you request for a certain relief in any given document, if there's no proof that warrants your entitlement to it, such as an objective witness like a video or audio, then that relief that you seek will not come to life. It is in your hands, just as he realized and he enforced it properly. Small things like that make huge difference.
You're interfering with evidence if you modify this record. So because I told them they faked the hearing, this and that, and I told them everything, they're going to fucking escalate it, dude. I'm a moron. YMCA feeding money to attorneys who are fucking me over because she's a stenographer who's fucking dating a lawyer.
And therein lies the second point. Whoever this is that you are listening to, it's dealing with this circumstance, once hired attorneys to assist him. Those same attorneys are the ones that actually screwed him over. Only a small portion of what the opposing attorneys did affected him negatively. But those who he put full faith in to assist him were the same ones that perpetuated the same injury that he intended to prevent, just to find out at a later date that he's as good as screwed with these attorneys. It is always iterated here that if you're going to enter into a contract with attorneys, which most people don't even consider it doesn't even cross their mind, because they do sign an agreement with these attorneys. That's a contract. And that agreement holds them harmless, separate from the fact that they are officers of the court and their duty and fidelity is primarily to the court, not you. You are a secondary client for the purpose of making money, not for them to seek remedy for you. You pay their bills for them. Without you, they don't eat. Without you, they don't pay for the gas that fuels their vehicle to move from point A to point B. You see those attorneys wearing suits and ties looking sharp? Most of them are not really where you think they are in life. Most people are food and meat, well seasoned to them. Unless you have some type of personal biased relationship with them, which for the most part you would think that would not be required in order for justice to be done. But in the realm of child support, in the realm of pen and paper, that is the requirement for you to get any benefit, relief, remedy, or proper assistance from an attorney. Otherwise, they will be the one to work against you. Such as this man's circumstance. 10 out of 10 people I have spoken with so far that have used attorneys end up realizing it was to their detriment. And they now begin with the intent of a certain, oh, well, he didn't do this right for me. She didn't do this right for me as an attorney. Therefore, it was wrong. I'm going to sue them. I'm going to say it's their fault. There's this thing called prosecutorial immunity, whereby insufficient assistance of counsel is deemed useless as a claim against them. And two, that contract you signed with them holds them harmless. We speak relating to those two things in these videos, respectively, regarding ineffective assistance of counsel and contracts when it comes to attorneys. Them harmless. We speak relating to those two, respectively. We speak relating to those two things, respectively. We speak relating, in short, if you're going to deal with a serious life circumstance and you're going to use an attorney, make sure it's one that just doesn't feed you some sales pitch because they see you're desperate and you're easy meat. And two, when you read that contract, try to figure it out and comprehend it and propose yours as an addendum to it. If you propose yours as an addendum that benefits you to whatever they propose to you, and that attorney does not accept it, know that that attorney does not have your best interests at heart. So long as you're not going off the rail, trying to turn them into your enemy through what you're proposing in the first place, while assuming they're going to help you. They're going to throw you out of their office or just hang the phone. So be reasonable with what you propose. But nonetheless, if you're reasonable with what you propose as an addendum to what they have you sign prior to you hiring them, and they say no, and you, again, considering you're reasonable, because most people, when they start drafting things on pen and paper, they get carried away and they lose focus of remedy and get stuck in intellectual masturbation and some other trash. So long as you know you are focused, reasonable, and you comprehend that you're working with them as a team, and that's the intent behind those pieces of paper, and you present it to the said attorney, and they say no and their contract is the only thing they want you to sign, then know that that's called a unilateral contract. There's no bargaining power on your end. Bargaining power is one of the attributes of contract that makes it unconscionable. We've made videos on that. That's the second point.
I'm not me. I have little girls I love. I have to be in their life. I have to fucking get these people and get justice.
The third point, the fact that people love their spouse, the fact that people love their offsprings, the stress involved in pen and paper, when it affects something substantial in one's life, is not a small amount of stress. There are certain things this man is dealing with that I really don't want to disclose in this video because it might be a little bit too much. But nonetheless, the intent is for you to learn from his experience. Whatever personal negative effect that whatever they have going on pen and paper, that they're using quasi courts on a colorable level to come after you, they don't care. It is absolutely irrelevant how it affects you negatively, here or later in the future. So when you start with a sense of justice, realize that you are dealing with those who are on the top hierarchy of what it means to be a psychopath. A psychopath is very analytic and does not care about your personal feelings, your personal effect. or how what they're doing have personally affected you. In fact, they will look at that and use it against you. Keep that in mind. That is a totality of how the system of child support works against people. It was formulated by people who are psychopathic, and people who are also psychopathic are found to be their fellow employees to work there and perpetuate it, because no one in their right mind would look at these things and still work under these entities to screw people's lives over like this. So whatever your sense of justice is, always be as objective and meticulous as possible, because the other one on the other end is not considering feelings to any extent under any circumstance. Again, it is easy to get carried away with the feelings of things and the intent of justice. But as you're running after justice, if your feelings diluted a little bit too much, you will lose track of what you're supposed to do as a remedy. And I find that to be far too common in those who deal with circumstances when it comes to pen and paper being used as invisible strings to screw their lives over. So at some point when dealing with a psychopath that you can't see, that you can't hear, but you see and feel their effects in your life through pen and paper, do not allow those emotions to take over what you consider sense of justice. Extremely important. The third point, the fact that people love their spouse, the fact that people love their offsprings, the stress involved in pen and paper, when it affects something substantial in one's life, is not a small amount of stress. There are certain things this man is dealing with that I really don't want to disclose in this video because it might be a little bit too much. But nonetheless, the intent is for you to learn from his experience. Whatever personal negative effect that whatever they have going on pen and paper, that they're using quasi courts on a colorable level to come after you, they don't care. It is absolutely irrelevant how it affects you negatively, here or later in the future. So when you start with a sense of justice, realize that you are dealing with those who are on the top hierarchy of what it means to be a psychopath. A psychopath is very analytic and does not care about your personal feelings, your personal effect, or how what they're doing have personally affected you. In fact, they will look at that and use it against you. Keep that in mind. That is a totality of how the system of child support works against people. It was formulated by people who are psychopathic, and people who are also psychopathic are found to be their fellow employees to work there and perpetuate it, because no one in their right mind would look at these things and still work under these entities to screw people's lives over like this. So whatever your sense of justice is, always be as objective and meticulous as possible, because the other one on the other end is not considering feelings to any extent under any circumstance. That's 3. Again, it is easy to get carried away with the feelings of things and the intent of justice. But as you're running after justice, if your feelings diluted a little bit too much, you will lose track of what you're supposed to do as a remedy. And I find that to be far too common in those who deal with circumstances when it comes to pen and paper being used as invisible strings to screw their lives over. So at some point when dealing with a psychopath that you can't see, that you can't hear, but you see and feel their effects in your life through pen and paper. Do not allow those emotions to take over what you consider sense of justice. Extremely important. That's 3.
So I drew up in a panic, like you can tell I'm in now, everything that fucking took place yesterday. I got a bystander report. They wouldn't give me the docket for the judge on the March 18th. They wouldn't give me the index of the filings. They would tell me this, tell me that. I go, no. You're deterring me away from my request. I'm asking you for a printed list of every fucking document and who filed it.
The 4th point. This has been mentioned in other videos when it comes to court 101s about 2022. But I think many people probably haven't watched some of those videos. It's been mentioned ever so consistently that the first thing that you do in any case is get something called the disposition or the case summary. Get a certified copy of the disposition, which will list the dates of what certain names of documents are filed, who filed it, what nature of those documents are, whether it's a notice, whether it's an affidavit, whether it's a motion, and the ruling behind it, and the chronological sequence of what occurred. Without a case disposition, and the case disposition is something that you can obtain without the case ending. Without the case disposition, or minimally a case summary, if they don't want to give you a case disposition, they will give you a case summary. Which the difference is the case summary does not have the official name of the clerk in it, whereby the disposition attests to the truthfulness of it. The clerk's name and interest is attached to it one way or the other. If you want to take it a step forward, you can then certify it. Quite often, they will not certify a case summary because they'll just casually print what they have on their screen for you, which is what they're looking at. Disposition is another section they have to formally go into, and it shows you it has the seal of the court, name of the clerk, so and so. But nonetheless, they both have chronological orders. When you have a disposition of a case, you now have eyes in a chronological order of what's going on. You now have a grasp on what you're dealing with. Most people dealing with child support or any type of related matter in a tribunal or public court, they don't even have that in hand. They're just going in blind based on their assumption of the chronological sequence of what's going on. They don't know what was filed last year. They don't know what was filed yesterday or last month. They're just going and doing whatever. In a battlefield, you have to know your terrain. One of the attributes of the terrain is what has been filed, what you are dealing with. Besides the complaint, besides the summons, there are many more things that go on that qualifies the faith of that case itself that's attached to your livelihood and your peace of mind. And you must know those intricacies. A disposition, certified preferably, is what will give you a bird's eye view that will give you the roadmap as to where you're going, where you should go, where the mud is, where the clear path is, where the dusty road is, where it's raining, whatever it is, you will see it. And you would know what to attack. Say you're doing an affirmative defense. You know what to do a general or specific denial to. Besides the complaint, you will know what to move to strike, what to move to withdraw. If you hired an attorney that screwed something up that you told them not to do, but they nonetheless do it, you would know what to refer to on the docket inside your document, the date of it, who was involved. You need to have eyes in a circumstance. It becomes less confusing. It becomes less convoluted. You become less emotionally involved because you see things for what they are, rather than looking at the interaction of how people deal with you and that being the limitation of it. That's as good as blind if you don't have the case disposition or minimally case summary. It's the 4th thing.
I go, no. You're deterring me away from my request. I'm asking you for a printed list of every fucking document and who filed it.
They cannot provide you every printed list of everything that occurred because, for one, it's probably thousands of pages. And 2, You can have all those thousands of pages if you don't know what you're looking at. It's just a bunch of papers. 3, you might even confuse yourself by having just a lot in front of you. But if you can target particular things that you've seen on the docket and tell them on this date, this document was filed, I need a copy of this according to the case disposition. Now you have a mirror effect to show them what's on their record. And you're specific as possible so they know you know what you are doing. Not to impress them, but you are about your official business. You have to be particular about what you have going on. You just don't walk in there saying, give me every document of everything that's been filed. Besides the Paperwork Reduction Act and the fact that it takes time and human nature of people being lackadaisical about doing something, they will just tell you we don't have it. They'll rather lie to you than do it because that's a lot of time and a lot of work. And then you're going to put a lot of time and a lot of work on yourself after that. And you will reduce the effectiveness of what your desired outcome is because you'll just be spending valuable time looking at A, B, C, D, E. When in truth, you're not even supposed to be looking at the alphabet. You're supposed to be looking at the Roman numeral of things. And it's in the first Roman numeral. You don't have the summarized version of the playing field. You don't have the map. That case disposition is the map to the terrain. From there is where you will point out particular documents. Without that, you are stressing yourself out and you are stressing someone who already does not want to assist you in the first place. Someone who just woke up, barely able to pay their rent, barely able to fill up their gas tank and come into work, dealing with people they don't like. And then you just come and say, print hundreds of pages or thousands of pages. And there they are looking at their computer, scrolling through it, looking at all this and saying, you want me to print all this, spend all this time doing this? And then there's 2, 3, 4 more people behind the line. And then I have 5 more things that I have to do. I haven't gone on lunch break. Consider those human nature of things. Because at the end of the day, you are still interfacing with humans. And humans are very fragile and unstable creatures. Make it easy for yourself. Make it easy for the peon that you're dealing with up there by knowing the terrain. Competency is the key. The first thing you should ask any given clerk relating to a tribunal or a public court is the case disposition. Certified. From there, you will now be able to pinpoint what's happening. And with time, as it goes on, every 3 months or every month, you will get a new case disposition, which will update what was input into the record. That's how you do these things. These are the etiquettes as to how you approach pen and paper when cases are opened that many people do not know. They're just doing everything left and right at once, which is all right, because at least you're trying. But use your energy in an effective manner so you don't waste so much fuel going in the wrong direction before you realize you now have to turn back and travel equivalent distance before you're now at point 0 to go to the right direction. Know where the right direction is so that you save energy and you save resource.
The way, because I'm panicked, dude. I'm freaking out. I'm living in trauma this whole entire time. I just don't know how to expose the fucking corruption. They wouldn't give me the calendar for the March 18th day where they faked the hearing, and there was no notice served to me, and there's nothing in the case file when I got it Thursday showing that we had a hearing scheduled.
Here now is the 5th point. When it comes to scheduled hearing and notices of it, if you're not on a federal level where they will email it to you and physically send you a copy, then you can go into the online docket to see the scheduled hearing. If you are in a tribunal, on a state level, or a public court, they will not tell you what the next court date is unless you are physically there to say, okay, this has been continued or move forward to this date. In his case, given that child support, we all know what type of venue they are. Administrative, arbitrarily. It's a private interaction going on, and you are merely the odd party to be used as a cash cow. That's the short summary of it. If you are clueless about what you're doing, if you had not taken preemptive steps before things got worse. The majority of people, when they start seeking relief, it has in fact gotten worse. By majority of people, I'm referring to about 7 out of 10 people. Only a very small population of people dealing with child support related matters, divorce decrees, so and so. Very small percent, about 3 out of 10, really preemptively do things to prevent all this. So when it comes to matter of hearing, given that it's administrative in nature, they would assume that they're administering an estate. You physically being there is only when they want to hook you, like a fish is caught with a fishing hook. Everything else, they just want to arbitrarily go over just to have the stuff in pen and paper is going over it, to your detriment. They don't require your presence. In this guy's case, it turned out that that prior attorney that he had before firing said attorney, he did not remove the name of that attorney on the record. So the notice of the hearing was going to the attorney who was fired, who said, screw you, you fired me. No, I'm not in your case anymore. I'm not under any obligation to inform you of what's going on. That is to say, if you find yourself hiring an attorney that you terminated because you realize they are screwing you over and are making things worse, go to the clerk and update the contact information of whatever role you're playing if you're the plaintiff or defendant. Because if you don't do that, each time an attorney withdraws, the contact information that venue, tribunal, administrative or not, public court, will be sending notices to will be that attorney's, not you. It is your due diligence to update the contact information. And on the note of contact information, when it comes to these pen and paper stuff, always designate a P.O. box separate from where you lay your head that you put on that record, or a location where you can receive mail that you put on that record. And 2, always create a separate email that it will send those things to that is not attached to anything else that you have going on in other aspects of your life. Same goes with phone numbers. Just a little thing that might go a long way when it comes to you creating a reasonable expectation of privacy for yourself when it comes to being in the hands of those who don't care much for you. A word is enough for the wise.
So, and I got witnesses that the fucking judge pushed away the stenographer I brought, and it's like the whole thing was just a sham. All of this was an act, a play, where I actually feel.
Yes, there are certain things that exist whereby I will clearly tell people what those tortfeasors did was actually correct because you were wrong. The acting judge pushing away and not acknowledging the stenographer that he brought is one of those things. Granted, administrative courts do not have stenographers. They don't keep record in a certain way because what they're doing, they are well aware that it's unconstitutional. And if you are to bring a stenographer of your own, you are supposed to provide a notice of that first. That is called a parliamentary rule. Any type of meeting, administrative or not, quasi meaning colorable, aka de facto, or de jure meaning the functional operation of it. When you are using a stenographer, or when you have a form of witness, which a stenographer is, because according to rules of evidence and other state laws that governs oath taken, stenographers are one of those parties considered to have the ability to take oaths for witnesses. Everything they write down is as good as an objective witness. And what you're supposed to do according to the rules of practices. Now, this matter is dealing with this situation at Illinois. So I'm going to use the Circuit Court of Illinois rules of practice as an example. Because believe it or not, the majority of the things administrative courts do still use and mimics the rules of practice. The rules of practice, I repeat, rules of practice are not the same as the rules of civil procedure. Rules of practice are not the same as civil procedure. But they mimic and adopt similar concept. In other words, rules of practice are as administrative as it comes. Administration of something is what the internal decisions as to how they run things are like. And it tells you part one, administration of the court. When you are in a child support venue, it's an administrative court. And if you are to bring a stenographer, you have to first provide the notice. When I'm having conversations like these with people, people are so charged up emotionally and just need a way to express what they've gone through that it's only towards the end of the conversation that I'm able to point out the steps of what they have done wrong. Because most people, despite the fact that what's being done wrong to them is true, they themselves screw up, which compounds onto what's being done wrong to them and subsequently clouds the wrong that was done to them because even they contributed to it. So here now is one of the things this man did wrong with the stenographer particularly. When it comes to the administration of any given venue at Illinois, which applies in most jurisdictions, given the fact that this man is dealing with this state, I'm showing this particular state's administration of the court. When it comes to stenographer, they're not going to tell him the reason why we're just ignoring the stenographer is because you're not doing what you're supposed to do. You haven't placed onto the record properly that you'll be bringing one, which for one, when you do that, they will perk up and act right. The mere fact that you've placed that on the record will make them sit up right because that is one of the perfect ways to appeal something. Even if the origin is from an administrative venue or not. So they will ignore that stenographer if you don't go through the proper rules of practice, which is you must give a notice to the venue that you are bringing in a stenographer. Which this man did not do. Again, if you've done something that's not quite right, I will tell you you have not. No matter how much the situation is hard, no matter how much the other party is also wrong, because you have to do it right in order to counterbalance or effectively negate the wrong they're doing. In this case, two wrong truly don't make a right. And if someone doing wrong to you that does not care to do right sees that you are also doing wrong, they will not care enough to say, hey, bud, look, this is where you went wrong, and this is why we're ignoring this. They'll just ignore it, which would add to the level of fire in you to basically mislead you to go deeper into how bad you feel they've treated you without realizing that there's something wrong on your end. Rules of practice, administration of the court, court reporters. All circuit court proceedings, which, by the way, most child support courts, especially in Illinois, are embedded as close corporations under the circuit courts. We've went over the concept of close corporations in this video. All circuit court proceedings are to be recorded verbatim by a certified court stenographer. Get this, approved by the chief judge or by digital, electronic, blah, blah, blah. What this is telling you is each time you want to bring a stenographer that is not already approved as an employee of the county, which automatically just sits there and types stuff up. When you bring yours in, there's supposed to be a notice that you provide to the chief judge, letting them know the case, the reason why you're bringing the stenographer, who they are, when that's going to occur. Simple as that. This man did not do that. with access to such records subject to the regulations promulgated by the Administrative Office of Illinois Court and any further order of the Chief Judge. In other words, what this is also telling you without speaking to you directly, but is nonetheless letting you know who controls the approval of stenographer, is also the Administrative Office of Illinois Courts. You send a notice of that also to these people. These right here are the subtle substance involved in what makes things works for people and what it does not, that most do not consider it. It does not even come into the forefront of their mind. It does not even exist at all. Therefore, when things don't work, they just get more frustrated. Whereas these are the small things that act as glues to put together all those blocks you've been piling over and over. You've put so much effort and time into piling it, and then if it crumbles, you get frustrated. But you were supposed to put glues in between them as you're piling it so that it doesn't crumble. This is the glue. You must not make these small mistakes, because on pen and paper, these are the small mistakes that makes all the difference. In short, if it's not clear, each time you want to bring a stenographer into a venue, administrative or formal, or whatever it may be, and you are bringing your own that they have yet to hire themselves, there has to be a notice provided to the Chief Judge at Illinois, the Chief Judge and Administrative Office of Illinois Courts, because the Administrative Office of Illinois Courts are the ones that oversee certain administrative matter like child support related things. Yep. It goes through them, orders that says this guy pays something and garnishes for debt collection attempt. All that goes through them. At your respective state, it might be called something else. At your respective state, in place of the Chief Judge, it might be the one hearing the actual case. It might not even be the Chief Judge. It might be another designated party just for knowing that stenographers will be brought. It might be the actual court reporter that you send a notice to in some states. In some states, it's not even as a whole, such as this one, applying to them. It might be by county. It might be by divisions and by certain circuits, like the First Circuit, Second Circuits. But in Illinois, it's all circuits, and you send it to the Chief Judge of whatever circuit you're at and the Administrative Office of Illinois Courts in order for you to bring in a stenographer for use. That's very important.
Like, their spiritual warfare is actually fucking consuming me, dude. Like, my head hurts, my mouth hurts, my back hurts, my hands are cramping up, I'm staying hydrated, I'm eating good. It doesn't matter. I can't even sleep. I didn't sleep all day yesterday since Friday.
Yes, whatever affects you emotionally does affect you spiritually, because the human emotions is the pathway to the spirit, a golden string that attaches us to everything before we were bound into this physical body as a vehicle on this earth, and long after we will be. That's the reason why those who have passed away, if they have a strong emotion, you will still see signs of them around, like their physical body or their voices or the strong feeling where they are, because emotions are attached to their spirit. That is the reason why if you constantly argue with someone emotionally, your mind absent of their physical presence, by the time you get there physically, you would play that out. It will be as though they heard you, they felt you. Same thing applies with the stress involved with these cases. It is a spiritual attack. The moment something is done in the dense physical realm and it affects your emotion, it is unequivocally, have not the slightest doubt that it is touching you substantively, spiritually. This is the reason why I always say, work twice as hard in a realm unseen as you do physically. As you're filing this pen and paper, as you're studying these things on pen and paper, work spiritually towards it. You have to do simple hypnotic things like use invisible inks to write your desired outcome on the paper itself. Do so so that as they're laying eyes on it, their subconscious mind is seeing what you invisibly wrote in there. If you have to use your thumb to write out your desired outcome in the document, do so. While the conscious mind is looking at the ink on the paper, the subconscious mind is picking up your desire that you've written with your thumb on the paper itself, even if you scanned it and they're looking at it digitally. If that's the minimal thing you have to do, if you don't know how to use spiritual paraphernalia, if you don't know how to use phase of the moon to use certain things like candles, or to use certain animal intelligence or plant intelligence to get things done, do that minimally. Because everything that affects you emotionally is affecting you spiritually. And if someone is affecting you on that level, it is up to you to take it serious, to do what it is necessary to alleviate that spiritual chain and burden minimally. If you want to take it a step further, to go on a spiritual offense, you can do that. But minimally, add an aid to all the things you're doing on a dense piece of paper by putting some spiritual effort into it.
The part about the rest, and there's so much there that I couldn't even get it out of me. And I have it in other documents. So it's like all I have to do is cut and paste it. I am paralyzed. I am paralyzed. Paralyzed. I don't know how many pages it could be. I'm looking at font size for whether it should be at 12 or what italics. Like, dude, I'm so diverted that this is insane. And all right, last thing, because I know I'm flooding and I'm just scattered. Is there any authority, the government, Secretary of State, all these people that actually is oversight? And this is a different form of a reality that I'm finding in case.
Yes, it's called a writ of mandamus. We went over the beginning of how it's done in these series of videos. It took hours in those videos. So we're not even going to go over that here, but know that videos have been done on it. It's called writ of mandamus, and it is best and easier done with administrative venues like these, with child support and things like that.
I gave every attorney emails and text messages how she was planning to, like I'm talking to attorneys about how I can keep all the money in the house and that she's not in any physical danger. Nobody pulled any of the evidence because I gave it to all my attorneys. I'm just saying that none of them did their shit. And none of my attorneys did anything with it. They just ignored me.
Again, if you're using attorneys, especially with child support related matters, 100% of people who've been in said circumstance have always came back and said, these people did nothing. In fact, they screwed me over. Listen to this.
No, it's in this case. My lawyer withdrew, and a week later, he filed a petition to collect attorney fees. And then...
Now keep in mind, attorney fees are often collected when the case is won against the other party to which that said attorney was initially hired to go against. In his case, when his attorney withdrew, he was making him pay for the attorney's fees. In other words, somewhere along the line of that contract that he signed when he hired that attorney, he subrogated himself that that could be done. Which is more reason for me to emphasize here the importance of you reading whatever it is you're signing, especially with attorneys. Or else, the one who you thought was going to assist you will turn you into a slave. Within that same case that you think they would assist you, they would also use that to basically act as a debt collector against you. Because, well, as far as they're concerned, you're taking food out of their mouth. You're taking food away from their table. They thought you could be a cash cow, and you thought you could be free after their assumption of you being a cash cow. So they decided, oh no, you will be my cash cow. Now I'm going to minimally somehow quasi-sue you by demanding an attorney's fee. That's wild. Attorney fees are usually obtained from the other party when victory is obtained. But there are clauses within the contract that people sign with these attorneys to say that you're liable for it if such and such occurs, and I assume reasonably based on what this man is presenting, that if the attorney was caused to withdraw for whatever reason that they justify, the man or woman will be liable for attorney's fee. And that's what's happening to him. His own attorney.
My own attorney. Yeah, and he used that in an affidavit. So yeah, he did that, and that's the thing. They're just trying to burden me because they know I smell blood, bro. They're just doing everything they can to stress me out. I find out that Bierman is the one who filed those 3,000 pages.
3,000 pages. If you find that someone did such a thing, there's something called the Paperwork Reduction Act. Public Law 104-13. 109 Stat 163. I believe it's from the year 1995. The reason why these people flooded that case with 3,000 pages, when I say these people, I'm not referring to the opposing party that's suing him for child support. It's his attorney, his own attorney, was to murk up the case to say, all right, you taking food out of my mouth. Well, I'm going to make it worse for you so you won't be able to find anything. And we'll just make the case clouded. Be very careful who you affiliate yourself with. We all get our parents telling us that, or someone who loves us telling us that while we were young. But that is evilly applicable in other aspects of life once we grow physically in the body. No one gives us that caveat until we learn the hard way. The way you battle that and you strike that with emotion, aka motion to strike, is based on this right here. Paperwork Reduction Act. Because these child support courts are working hand in hand with federal agencies. We've shown how that is in this video when it comes to child support. Of course, Paperwork Reduction Act is a federal law, and most states have something similar to this. So both can be used. The next step to do with such a circumstance is to strike such document, because it's a waste of time for the court. It's a waste of time for the parties. And it increases the cost of litigation, and it convolutes the intent of justice. Because that was the intent of his attorneys that he fired. They just wanted to make things hard. Of course, you don't put it that way, but you used objective standards just mentioned. And whatever else you see that's reasonable, place it there. This is also another reason why convolution of the records, the bloating of the record, is another reason why you get the case disposition. You can know that they filed all these pages all you want when you look it up. But if you don't know the chronological orders of what was filed when, you would not be able to isolate what was a 3,000 page and what was not. Very important to obtain the case disposition. In his case, they were hoping and trusting he does not know what that is enough to even get it. That way, he remains blinded by the thousands of pages that probably already existed prior to the 3,000 page that they filed in order to further cloud the case. Obtain the case disposition.
What do you do at that point? Bierman were my attorneys. They're right across the street from to bloat the record, so I couldn't obtain it. Man, it's a joke. That's when my attorneys motioned to reopen an emergency hearing, to reopen and rehear and vacate. It's ridiculous. Who would ever write that? And what they did with the first page that said reopen the order of protection, they changed the contrast out of the other 3 pages that were filed with that. They changed the contrast to be dark. So if you scan that, or if it gets put into electronic storage, you can't read it. Exactly. That when you review, I want transparency and justice.
And that is another reason why I'm making this video. Did you just hear what this man just uttered? When certain important documents are filed, this is a tactic that is being used against people that you must know about, whereby documents are placed on the record and scanned into the record in a manner whereby when you obtain it and you scan it, the contrast causes you to not be well informed. So you cannot make well informed decisions. In other words, it's as good as you not even knowing what's on the record because you can't read it because of the way that it's been printed on the record. Said types of documents, you can move demanding for it to be stricken or suppressed, or demand that it be filed properly in a way that is conspicuous, so that due process, procedural that is, because there are two types, it's substantive due process and it's procedural due process, so that procedural due process can be properly done. How can you properly defend yourself if you're the defendant? How can you prepare a defense if you're a defendant? If you're a plaintiff, how can you properly respond or reply to any given contentions or documents if it is not understandable because it cannot be read? You are supposed to strike it or demand as alternative relief that they refile it properly. These are traps that they engage in to frustrate people. It's up to you now to strike it down and to demand them to refile it. So those are few of the things that people go through. I don't want to keep going on with it. There's so much going on that if you hear this guy's circumstance, you would almost want to cry for him. But these are some of the things that I think I can disclose publicly to people for those who might be dealing with this now, or this video might prevent them from dealing with it in a stressful manner if they just know some of these intricacies. Until next time, take care. Best of luck.